and welcome to NSE's webinar on strengthening institutions for the coming decade. This is the fifth webinar in the corporate governance webinar series that we have had, co-organized by NSE and Excellence Enablers. In previous sessions, we've had discussions on crucial topics pertaining to corporate governance, including crisis management, role of regulations in fostering corporate governance, instruments that companies can implement to improve governance, and ensure business sustainability and conflict of interest. Broadly speaking, institutions are mechanisms that define how humans or groups of humans interact with each other politically, socially, and economically. And these rules or codes of conduct, in turn, are established by the culture, and it's therefore crucial that institutions represent the collective will of the population. Institutions in governance parlance reflect to formal institutions such as the government and its departments, the judiciary, law enforcement agencies, regulatory bodies, and markets. Stable and robust institutions are fundamentally important to improve governance standards and achieve sustainable economic development. Today's session will focus on how institutions can be strengthened to address the requirements of the real world and endure the challenges of the future. We have some highly knowledgeable and experienced speakers on the panel today who will share their thoughts with us. May I now request our MD and CEO, Mr. Vikram Limai, to deliver his welcome address and start today's session. Over to you.
Thanks, Tirthankar. Good evening, everyone. Distinguished panelists, Mr. Arvind Datar, Dr. Mohan Gopal, Mr. Damodaran, a warm welcome to you for today's webinar on strengthening institutions for the coming decade. Institutions govern human behavior and regulate businesses in a society. Their primary responsibility is to ensure trust by encouraging adherence to laws of the land and ethics, resolve conflicts, and deliver justice to the aggrieved. Institutions must also ensure equitable access to basic resources and judicious use of these resources. It has been well documented in the literature that the strength and robustness of institutions determine the level of economic development of a country. It can also be said that economic development in general leads to the development of institutions that help sustain it. Recent events around the world, however, have tested the strength of the best democratic institutions. Illustratively, the pre- and post-election proceedings in the United States, culminating in the storming of the Capitol, would perhaps stand out as an event as unforeseen as the pandemic. The fact that it has happened in a democracy like the United States serves as a course for introspection for democracies around the world, and to realize the importance of preserving the institutions that define and protect our value system. Stock exchanges are important market infrastructure institutions in their role in ensuring fair trading practices, efficient dissemination of information, and a level playing field for all market participants. It is the institutional strength of an MII that, amongst other things, allows it to deal with the crisis. Global markets have seen a few major incidents in the last 2 decades, and our markets have been able to measure up to the requirements each time. At NSE, we have always encouraged debate on relevant issues, and today's topic is as important as any. Beyond monitoring listed companies and trading activities, NSE encourages policy advocacy by conducting regular dialogue on policies and best practices, by inviting regulators, practitioners, and members of the academia. The setting up of NSE Center for Excellence in Corporate Governance in 2012 and the Corporate Governance Webinar Series are important steps in our endeavor to encourage best corporate governance practices. The objective of the webinar series with Excellence Enablers is to conduct discussions on topical issues in the areas of corporate governance. Over the years, NSE has built a wide knowledge repository in the field of corporate governance, which is made available widely for the public benefit. NSE also encourages academic research in this domain through collaborations with educational institutions and think tanks. On behalf of NSE, once again, I welcome you all to the webinar and hope you find useful and insightful takeaways from today's deliberations. Thank you very much.
Thanks a lot, Vikram. Allow me to introduce the panel today, please. Mr. Arvind Datar, I'll begin with him. Mr. Arvind Datar is Senior Advocate, Supreme Court of India, and General Editor for the Ramaya's Guide to the Companies Act, and Chief Editor of the 11th edition of Kanga and Palkiwala's Law and Practice of Income Tax. To just give a short introduction about him, he's a leading and prominent senior advocate with more than 30 years of practice. He practices at the Supreme Court, the Madras High Court, and other high courts. He is an authority on taxation, company law, and constitutional law. He has appeared before the Supreme Court in several landmark cases. He is also a prolific author with several best-selling books like The Commentary on the Constitution of India, The Guide to the Central Excise and Guide to Excise Procedures, and Nani Palkiwala, The Courtroom Genius. In addition, Mr. Datar has authored over 150 articles for various journals. He's the general editor, as I said, of the Ramaya's Guide to the Companies Act, and he's also a trustee of the Palkiwala Foundation, Chennai, and a director of the Nani Palkiwala Arbitration Center, Chennai. Mr. Datar was the president of the Revenue Bar Association and joint secretary of Tamil Nadu Medication and Conciliation Center. Mr. Datar, welcome to you on this panel. My next guest is Dr. G. Mohan Gopal, former member, Law Commission of India, former director, National Judicial Academy, and former vice chancellor, SIU, Bangalore. Dr. Gopal has been the head of the National Judicial Academy of the Supreme Court from 2006 to 2011. He oversaw the transformation of the academy into a vibrant forum for dialogue on justice between civil society and judges, and made it a key catalyst for institutional innovation on judicial reforms. Since 2011, Dr. Gopal has been heading the National Court Management Systems Committee of the Supreme Court, pioneered by him as a new national focal point for systemic improvement of the judicial system. A former director, vice chancellor of the National Law School of India, University, Bangalore, Dr. Gopal is also a former member of various national regulatory bodies. Dr. Gopal, welcome to the panel. Last but not the least, I introduce Mr. M. Damodaran. Mr. Damodaran, of course, is Chairman, Excellence Enablers, and former Chairman of SEBI, UTI, and IDBI. He serves on boards of directors, including as non-executive chairperson of Interglobe Aviation, and on advisory boards of several companies. Mr. Damodaran led successfully the revival efforts of UTI and IDBI. He created the unique Stressed Assets Stabilization Fund, SASF, which helped clean IDBI's books. He was also the former elected chairman of the International Organization of Securities Commissions, IOSCO's 80-member emerging markets for 2 years. Mr. Damodaran has chaired several committees of the Government of India, RBI, and some chambers of commerce. And prior to this, he was former chief secretary of the Government of Tripura. He is a recipient of several awards and recognitions. Mr. Damodaran, of course, welcome, and I leave the floor to you now, sir, for the panel discussion.
Thank you, Deepankar, and thank you, Vikram, for those opening comments. What I will do, considering that I have two eminent panelists who will be speaking, what I will do is to set the context for today's discussions, point to the importance of today's subject, and then facilitate a conversation in which we will look at why things are not as good as they ought to be, what can be done to make them better, why we need to make them better in order to ensure that the potential of this great country is not lost out by inadequate institutional performance. So let me begin by referring to an old American phrase, if I may call it that, or a sentence: if it ain't broke, don't fix it. I'm not going to discuss what is broken in the United States, from where that philosophy comes, because it's for them to fix. Whether things are broken there or not, we get to see on the television screens and in the newspapers. But closer home, there are some institutions that have either lost relevance or lost legitimacy, or have proved to be inadequate, whether in terms of the objectives with which they were set up or the capacity that they have to deliver on what they were intended to do. We have no shortage of institutions in this country. Our philosophy has always been, give me a problem and I will give you an institution. We never thought about, give me a problem and I'll give you a solution. We moved from there to, I will give you an institution. Therefore, there are institutions which are having turf issues with other institutions. There are those that lack role clarity, and if an institution lacks role clarity, if society that it seeks to serve will suffer on account of that lack of role clarity. And then there are institutions that are inadequately manned even from the day they were set up, and therefore the expectations from them clearly cannot be met. If you look at the three major organs of government, for years the judiciary has stepped into the areas of the executive, on occasion perhaps legitimately because the executive did not measure up, did not do what was expected of it. In recent times, the judiciary is getting into the areas of the legislature. The legislature itself is not devoting enough time to discuss important legislations. They're all being passed without discussion and debate or get reference to the select committee. There are regulatory organizations that could do far better than they're doing at this point of time. Then there are investigative agencies, big institutions in themselves, and their track record is not exactly the best. It could be much, much better. So I could go on and on, look at any category of institutions, and then look at what their inadequacies have been. But the reason we are here today addressing this topic is because I think India is at a moment in history when, if institutions pull their weight, if they meet expectations, far more could be seen in terms of what this country can accomplish than is being seen at present. And to do that, we have two persons who I think live law, breathe law. I don't know whether they eat law. They're reasonably well-preserved people. So how much of law they consume in a literal sense, we don't know. But law is, it is said, a jealous mistress. And I think they devote a lot of time to law. They think a lot on issues like this that impact the lives of the common man. And they have very strong views on the subject. And without further ado, I would request them to come in to shed some light on where the majority of our institutions are, what has gone wrong with them, are there things that can be fixed, are there institutions that are past their sell-by date and should be quietly closed, is there at all, and I don't think it doesn't look to me that's necessary, is there a requirement for new institutions? More importantly, the capacity building institutions, is that getting attention? And whether there are turf battles that are setting the country, economy, and society back, turf battles among institutions. It's a large canvas, and to paint on that large canvas, I will first request Dr. Mohan Gopal. You've heard Tirthankar mention the positions he's held. He has dealt with the entire range from students out of school getting into a college, a top-class institution in pursuit of legal education. And he's also, in a sense, facilitated a better understanding of the concepts of law, justice, and equity among persons that are members of the highest judiciary in this country. He's seen the entire range. So without further ado, over to you, Dr. Mohan Gopal.
I want to start Damodaran for the kind invitation, words, and Mr. Patnaik for the kind words and the introduction. I'd like to say hello to Mr. Arvind Datar, who I've known and highly respected for many years. He's truly one of the great minds of our legal profession. So it's a privilege to be on a panel with him, and of course with Mr. Damodaran, who's also a very profound thinker about what's going on in our country. I've had since perhaps in my past life, I've had to suffer through the enormous confusion about this issue of governance in general and institutions and organizational change for many years. I was working at the World Bank in Washington, D.C. in the late 80s, the early 90s, late 80s particularly, as the Soviet Union was collapsing. There was a big controversy about developing an institutional and legal democratic framework in the transition economies. And there was a huge push by people inside the World Bank to put in political conditionality on democracy. And we in the legal department of the World Bank, I eventually was chief counsel there, we pushed back and we said there is a prohibition against political activity. And so you cannot, the World Bank has no business to set conditions on democracy. And finally, of course, the advantage of being the legal department of the World Bank is there's no appeal from that, because it is an international organization. So if there's consensus in the legal department, that pretty much takes care of it. So, but the economists were very clever. They created this whole business of institutions and institutional reform, which was already dormant and around, but they built it up into a very massive issue in development financing and this whole area of governance. And from governance, institutions and institutional frameworks. And that replaced the earlier emphasis in the development institutions on public sector governance. So actually what I saw and I understand from the book, this interest which still continues on governance and institutions is really an attempt by bureaucrats and technocrats to control the political system. And that is where the difficulty is, because it is politics in sheep's clothing. So people with distinct ideologies come in and present their arguments as steps to this discussion. Obviously, there is a political economy and political dimension. There is a management dimension. There's a technology dimension. But at the end of the day, it is the presence, the unacknowledged hidden presence of the politics of this discussion and the ideological choices that underlie the debate is what makes it very difficult. So if we go back, for example, to the history of the United States, it's very interesting that the Civil War in the United States took place in the eighth decade of its constitution, of eighth decade of the Republic. Sorry, eighth decade of the Republic. We are now in the eighth decade of our Republic. And I believe we are in a civil war, in a very different kind of civil war. And during the American Civil War, from the point of view of those in the South, the conservative people in the South, all institutions collapsed. Institutions were in a mess. The rule of law collapsed. There was anarchy. Abraham Lincoln basically tore up and threw into the wastepaper basket, the decisions of the U.S. Supreme Court after Scott versus Sanford, in which basically the Supreme Court of the United States upheld slavery and denied the humanity of slaves. So from the point of view of the South, the institutions of the United States were in peril and in decline. For the North, they were constructing a new nation. About over 2% of the population of the people were killed in that civil war. Vast economic resources were destroyed. Vast institutions were destroyed. But they did not realize, I don't think even Lincoln's vision was very, very simple. He said, this nation cannot be half slave and half free. That's what drove his vision. But that political vision unknowingly laid the foundation of what is today possibly, as we can see about after Trump, perhaps the country with the strongest institutional framework in the world. And so from a destruction of one set of institutions arose a very powerful set of institutions without there being sort of technocratic design behind it. And so I think we need to understand that we are also now in the middle of a struggle. So the way we look at our situation in India, the glass is half full or half empty, depending on what's your poison, So I think, so the challenge for us in this topic, I think, is some common areas where we can all work together, where there is political consensus and where there is technocratic and managerial and administrative consensus, because there are lots of things that can be fixed, notwithstanding the larger political and ideological struggle that's taking place. But I think first we need to be honest about the ideology and the politics that we are espousing in the name of institutional reform and governance reform. And second, we need to identify common ground to move forward so that we can achieve small gains. I often read a 1917 small article written by Mahatma Gandhi 2.5 years after he returned for good from South Africa in 1907, returned in 1915. This was written in 1917, called about travel in the third class. And if you read that article, the amount of bribery, corruption, dirt, filth, and all that was going on in the British railways. They called it the Indian Railways, but in 1917 it was directly administered by the British. It is unbelievable. And so from the point of view of some of those people, not all of them, not if you go into the hinterland of the north, but certainly in the south where Mr. Datar and I come from, the things have improved since the Gandhi's 1917 in about 100 years. In terms of the plight of the third class compartment, there's no more third class at all. So I think we can see that in some areas, and technology has contributed to that. Computerization of the tickets, that railways has used past 20, 30 years a lot of technology to improve and strengthen its institutional framework. So I think we do have common ground where we can, regardless of political differences, find a way to go forward and make improvements as we have done. And I don't think there is any need for despondence. Now, what I thought I'd do in the remaining 3 or 4 minutes is to identify, us changed. As I've been saying, this is an old issue which actually goes back to ancient times, the challenge of governance, challenge of good administration. And we also make a distinction in this discussion between institutions and organizations. As Douglas North, the Nobel Prize winning economist, who's the main figure in institutional economics, has defined it basically in simple terms. Institutions, he says, are rules, formal and informal, including the way they're actually enforced. So when we talk of institutions, we're talking about a set of rules. Organizations are different. It is converting something into an instrument. Sometimes rules help in that, sometimes rules come in the way. So we're not talking of organizing, we're talking of institutionalizing, which basically means ultimately the Latin word institution means a law, basically, or a precedent, not just a formal law, but a custom or a precedent. So how do we create a framework of rules is the challenge that we're looking at. And that's where I think we ask ourselves, that enterprise of creating rules, what has changed from ancient times to now under the Constitution, and what are the challenges that still remain from the old days? And I would say there are, and I'm not discussing them in detail at all, I just list 5 very important changes to this enterprise of institutionalization, which is basically to set our activities within a framework of rules and customs and laws so that it becomes more predictable. And from that idea of institutionalization emerges also the idea of the rule of law. So one area where there's been a lot of change, and I draw this from many years of conversation with Mr. Damodar, and I used to ask him what has changed. And he used to say, what I used to decide as an entry-level IAS officer is today decided by the cabinet. So clearly there is an upward pull of power and a strong centralization over the last 20 or 30 years. It is going back to sort of colonial and pre-colonial feudal times, away from the decentralization that the Constitution and federalism that the Constitution advocates and envisages. And there seems to be a lot of evidence that centralization has enhanced corruption, has enhanced many institutional failures, and there is probably not a single successful institutional country in the world that is not democratic and decentralized in a very substantive way. So one issue that is new to India, I think, is this idea of decentralization and devolution of power, deconcentration of power, and decentralization of power as very essential for us in the long term to build sustainable institutionalization, because I think the evidence is very clear that long-term sustainable institutionalization is not possible Although you can make short-term gains, long-term sustainable institutionalization is not possible without substantial decentralization, devolution, and deconcentration of power. The second thing I think that has developed is new to our country since 1950s democracy. And I think that has two impacts. One is the impact of elected officials having a role in governance. And again, depending on who you are, some people think that's terrible because these illiterate, corrupt, savage people are having power as the refined elite. Or from other people's point of view, it brings voice of people into governance. And maybe the truth lies somewhere in between. But so democracy and the impact of elected officials on administration and their role in institutions and institutionalization, their difficulty with the concept of institutionalization, their challenge of the concept of institutionalization, I think is a crucial difference from the past. Also the concept of the rule of law, as I said, which is very central to institutionalization, versus the need to be responsive and equitable and respond to the needs of the moment, especially of poor and powerless people. There's a tension which we feel in the law and in the judiciary very, very sharply. The third area, I think, where there's been a huge change is reservations, the impact of reservations on institutionalization. Because there is the argument that reservation, only caste reservation, mind you, not women's reservation, not regional reservation, not reservation for foreigners and NRIs and OCIs, but only reservation for lower castes is seen as reducing quality and detracting from merit. And I think that's a completely spurious argument, but that is an important argument because that is used very often as an impediment to institutionalization. The fourth very important change is the inability to use military force. That's actually, we are going back to the old days. But for a long time in India, after the constitution, it was impossible to use military force or police force to compel people to obey rules, which is how institutionalization is wrongly seen, as simply obeying rules without looking at the quality of the rules. And suddenly that changed. And people, when democracy came in, the ability of the state to use force declined, although the recent past, I think that change is being reversed. And lastly, I think it's the struggle between order and liberty that is very new. Order, which is always important and is still very important to the traditional conservative people in our countries, being challenged, as Lincoln did in the United States, with the idea of liberty. There are three, I would say, old poisons that continue with us since time immemorial, probably since the beginning of time. One is arbitrariness, and by the decision makers who act in their own self-interest. Second is corruption, and the third is impunity or lawlessness of the powerful. These three are continuing poisons. The other five are new challenges to institutionalization that we have to face as a result of our democratic constitution. And I think last point I want to make in this context is, as Mr. Damodaran said, and Mr. Datar knows, in fact, we've discussed this also in the past. I worked a lot for the last 16 years on judicial reform. And one of the key points relevant to this discussion that I think is neglected, but is responsible for the indifferent purpose of our judiciary, or the differential impact of our judiciary on the poor versus the powerful, is the absence of performance standards. And I think, compared to any other judiciary in the world, we don't have measurable performance standards that by which we can measure our institutions. So we are not just a judiciary, but whether it's a civil service, the district administration, or universities, there are very scant measurable performance standards that are objectively measured and enforced. And I think this is an area we can find common ground and make progress, because ultimately, to me, institutionalization can either be used to suppress people by putting in oppressive rules and forcing them to obey them, or institutionalization, as has been done in many democratic countries, can be used to build what I call the fine print of democracy, the detailed rules that have to be obeyed by the powerful, not the powerless, that will ensure that freedom, liberty, and equality can flourish and create a society that is ultimately bounded on liberty and not on obedience. So lots of challenges. I think there are common grounds on which we can move forward, but we must recognize the limits of what we can solve, that we must leave the political decisions to the political sphere, respect that, and then work in areas where we can make progress and I think make these institutions work better. What those specific areas are, we can come to during the discussion. Thank you, and apologies if I've overstepped my time.
Thank you, Dr. Mohan. Extremely thought-provoking comments, and I think long after this webinar is over, some of us will really get to think a little more about those. You mentioned 3 poisons. I was hoping you would mention a 4th. I don't hear it anywhere. I believe that psychophancy is at least as problematic in India as corruption is. But I'll state that and leave it at that, and welcome Dr. Datar.
Good afternoon to everybody. I must first thank the National Stock Exchange and the Excellence Enablers for inviting Professor Mohan Gopal and me to speak on strengthening institutions. I must thank Tirthankar Patnaik, Sri Vikram Limay, and Sri Damodaran for inviting me. Special thanks to Mr. Damodaran for conferring a doctorate on me. You know, there's this one insatiable desire in Tamil Nadu from where I come, where everybody wants to be a doctorate, and the desire is inversely proportional to the person's ability. So virtually if everybody of any substance is a doctorate, and dare you call a particular person, particular politician, and delete his doctorate. I remember my father was in the Merchant Navy, and he used to run the Sea Scouts group. And at that time, whoever the chief minister was, they printed some 2,000 invitation cards, and they forgot to put the prefix doctor. And all the cards had to be scrapped because that was supposed to be very insulting. The man had not even passed school, but then he had to be called a doctor. Anyway, so thank you for, in fact, last 2 days, at 3rd or 4th time, somebody referred to me as a doctor. But I'm just a plain advocate. And I had the privilege of working with Professor Mohan Gopal, giving some lectures at the National Law School when he was a director. He really brought up the institution. And again, at the National Judicial Academy, he was kind enough to invite me quite often at the Judicial Academy for lectures. It is to his credit that both these institutions are still doing very well. Ultimately, it's a legacy he has left and people have carried on. Now, since the time is short, I just thought that on this issue of strengthening institutions, I think today is a good time as any, because in particular, as we come to the Republic Day, I realize that we are now going to enter the 8th decade of our Republic. I suppose 70 years are over and we're going to start the next decade. I've always seen that we should now plan for the next 10 years. I just read Michael Pillsbury's The 100-Year Marathon of China, and I always think that we should plan our own 10-year marathon in the context of institutions. Now, it is my belief that our laws are in place. I don't see any great need of a constitutional amendment or great need for any legal reforms. I always believe the laws are in place by and large. And if you only implement the laws, as Professor Mohan Gopal says, if you just implement them, the important people implement the rules, we'll be much better off. Now, quickly running through what are the suggestions I would make for strengthening the institutions. I'm going to first mention, and in fact, when I was just working on this, doing some research for this particular lecture, I just went back to Montesquieu, and I was I'd read parts of it in law college and so on and so forth, but then it is astonishing that this gentleman wrote this theory of separation of powers in his book, The Spirit of the Laws, as early as 1748. And he is the basis for the US Constitution. Subsequently, partly, we also took in this question of separation of powers and so on and so forth. But at the heart of separation of powers is that each wing of the government is an institution. It has sub-institutions, and the strength of each institution also depends on the strength of the minor institutions or sub-institutions within that particular framework. Now, I would suggest, as far as Parliament is concerned, what is worrisome for me as a lawyer is that very little parliamentary debate takes place before a law is framed. In fact, today, There is virtually no difference between a government notification and an important legislation. It is framed by the ministry and it is just pushed through parliament. Statistics show that the references to select committees are getting less and less, which is not a very good thing. So perhaps it should be made perhaps as a rule, as a convention, that if it's a law which is going to have, if it's not just a mere amendment, if it's not what we call small repairs, if it's going to be a new law, like say the Farm Bill or the Insolvency Bankruptcy Code or something, Aadhaar Bill and so on and so forth, it should be sent to a select committee and come. There is no earth-shaking hurry. In fact, I believe that a lot of the problems of the farm laws could have been avoided if it had gone through parliament. So the first thing is that strengthening of institution of parliament itself, which is the most important institution of all. And there, I think the lawmaking should receive much more attention. I come next to the institution which I'm closest to, which is the judiciary. And two things are very, very important as the years go by. I think I don't think anybody has done as much for judicial reform as Professor Mohan Gopal has over the years. But unfortunately, most of it is in theory. We have not really put down to practice. What's important is where the rubber meets the road. Now, take for example, judiciary at the High Court level. I leave the Supreme Court alone. I'll just say the High Court level. One important thing would be that now we've got this collegium system. There is no point fighting it. The NJC was amended. Was introduced. I appeared against it. We got it struck down. But today, as the system stands, strengthening the high courts as an institution, according to me, doesn't require any major change. There's a memorandum of procedure. We have filed a PIL. All that we say is, let there be a time-bound program for appointing a judge from the time his name is recommended by the High Court Collegium till it is cleared. There are 6 or 7 steps. Let there be a time limit for each step. Today, the names have gone. Some names get fast-tracked and appointed quickly. Some names languish for years, 2 years, 3 years. And the sad part is, out of 1,100 odd judges, in fact, Justice Gogoi used to lament that the vacancy is almost 40% out of 1,100 judges. Now, if 400 posts are vacant, it is something very, very serious that institutions simply cannot gain strength, and its very legitimacy becomes difficult. I mean, if in the Bombay High Court, if a suit is going to take 25 years, you might as well not have a court for all practical purposes. So this is the point. So first is simple tweaking. We don't need any major changes. We only have to have a time limit that from the time the High Court Collegium makes a recommendation till it goes back, all the steps have been laid down in the 3 judges' cases. The memorandum is there. Everything is there. Only it has to be implemented. The greater worry is the district judiciary and the small cause court and the lower courts. Again, I'm amicus in a matter which we have made a suggestion to the court that just as you have very good quality civil servants and so on, because of the strong entrance exam, this is a rigorous entrance exam procedure. So it is not possible at the moment to create an all India judicial service. You require to go through Article 312. I won't go into that now. But what we had suggested was, why can't you have, let's say on the 1st of May of every year, you know how many district judges posts are there, how many sub judges posts are there. Have a proper entrance exam, like you have your IAS entrance exam. This syllabus can be announced in advance. They can be a theoretical exam. They can be an interview. And then you can have selections. Because to the credit of the Madras High Court, some of the judges, they sat together. They had a very rigorous selection process. And I'm proud to say that some of the best district judges today are from Tamil Nadu, just because the High Court took personal interest and really ensured that we had very high quality people. But the point is, for a post of 7-9 judges, you're almost 2,000 applicants. So there's a huge crying need for people who would like to join the judiciary. But there's no point putting an advertisement in October saying there's an exam in November, syllabus is not properly known, nothing is known. But if it can be institutionalized, that every year on the 1st of May, like the National Law School exam used to be, there is an examination for candidates who would like to get appointed to the judiciary, depending on the number of posts, that would be a great help. We keep talking of the High Court and Supreme Court. What is more worrisome are the number of vacancies that exist at the lower levels of the judiciary, where 98% of the litigation goes there. According to Chief Justice Venkatachalaya, hardly 2% to 3% of the cases come up to the high courts. And it's also important to note that statistics show that we talk of high court arrears, but 54% of the high court arrears are just in 4 high courts. And among the lower judiciary, 52% of the arrears in the lower judiciary are just in 4 states. So it's a case of focused attention to these problems. And this institutional problem of judicial delays can be substantially sorted out without any major statutory change. So I've covered these 2 points. The third point, which is very, very worrisome to me, and I've been fighting this battle from 1991, is this tribunalization of justice. For some reason, we talk of separation of powers. We talk of the executive, legislature, and the judiciary. And you have got this strange hybrid animal called the quasi-judiciary, which is basically a tribunal, which is under the executive, but functions like a judiciary, functions like judges. And unfortunately, the system or the bureaucracy is not willing to give them autonomy. There's no time to get into how the GST is structured, but a tribunal which is part of the executive is actually an oxymoron. It's not possible to have a tribunal which is completely independent. And in England, though they have a strong tradition of independence, they felt that it is not the independence of the tribunal in theory, but they should appear to be independent. That's why all of them have been shifted out of the executive, and they all come under the Lord Chancellor, under the Justice Department, and the executive has nothing to do with the tribunals. Their funding, their infrastructure, their staffing, everything is manned separately. I'm happy to say that today we have succeeded in a matter filed by the Madras Bar Association, and the Supreme Court has directed that all tribunals must come under the law ministry and function independently. So institutions, as far as tribunal is concerned, there's a crying need to make them independent, to make them free from the government. As Professor Gopal pointed out, that the most important thing is any institution will get legitimacy when it is insulated from the political and from the legislature, from the ruling party, as it were, and the executive. If the regulator works independently, be it SEBI, be it the Election Commission, be it the Control Auditor General of India, all these are institutions which have to be, some kind of a firewall has to be there between that institution and the government, and not just de jure, but de facto as well. Actually, it has to be there. Now, these are points. And I just mentioned about the institutions. One example we have got is the Election Commission, and we still remember how the Election Commission was transformed by Mr. T.N. Seshan and the kind of respect it commanded over the years. This is just shows that if one institution is robustly independent, what a great change it can make to governance throughout the country. And finally, I just conclude that one other group or institution which needs to be nurtured are the NGOs, the non-governmental organizations, which are doing human service. And one very, very problematic issue in India is that these NGOs, it is almost a punishment to run them, because you got the way the income tax is structured, the way the regulations are structured, the way the FCRA is structured. It is extremely difficult to run the NGOs. Now, at a time when we have been hit by the pandemic, there have been wonderful organizations doing good work on the institutions. I think it's time that as an institution, we nurture the NGO structure. It's not difficult to control them. There are enough mechanisms to control the bad apples and allow the good apples to function. For the life of me, as a tax lawyer, you have corporate social responsibility. 2% of your profits must go to 11 categories, as mentioned in section 135 of the Companies Act. Now, I don't know why this expenditure can't be claimed as a deduction. It is really unfair that you are compelled to part with 2% and yet you pay tax on that. And this is one institution which has to be encouraged. These are the NGOs. And I will finally just stop here. I'll leave it to the discussion panel. But Professor Gopal also mentioned about Abraham Lincoln. Those of you who have read his Team of Rivals will know that what great difficulty he went in setting up his cabinet, including his rivals in the cabinet, because one leader who placed the nation above everything else, and he said that no matter what happens, slavery has to go, the kind of price he paid for it. And I think in the end, one thing is very clear, that as a general rule, what is easy in the short term is always harmful in the long run. And what is difficult in the short term will always pay rich dividends in the long term. If we are willing to wait and pay the price, today we'll reap the rewards tomorrow. Let's hope that we place India first. And I really hope that in 2030, at least we cross the 5 trillion economy and we have strong institutions. Thank you, everybody, and wish you a wonderful decade ahead. Thank you.
Thank you, Mr. Datar, for those comments. It's interesting that you chose to focus or certainly started your comments with the judiciary, where a lot of people have great hopes, and what we see and read and hear makes us feel far more despondent than we ought to be, because the disconnect between the expectations and what actually we see happening is most in organizations, institutions, wings of government that are seen as the last resort for people who have nowhere else to go. I want to ask Dr. Mohan a question. You did mention that there needs to be a lot of thinking on what it is that can make the right changes in society. Do you think one of the things that is missing is that we have not defined accountability correctly? Not just in our laws, but in our various rules, regulations, even in our own minds, in terms of whom do you hold accountable when, for what omission or act? Because in our system, errors of commission are punished. Errors of omission are never punished. Part of the problem is if I don't do anything, I'm safe. I can go through close to 4 decades doing what I was not doing what I was supposed to do, but not making mistakes, except the mistake of omission. And so nobody pulls me up for it. Is that one of the problems that needs to be fixed?
Yes, certainly. I think that's a very, very important problem. And when I was at the think tank, the Rajiv Gandhi Institute for Development Studies, one of the areas that we took up for work precisely on this issue was updating and modernizing the Prevention of Corruption Act. And finally, I think Mr. Jaitley took it forward after the government changed and did bring about some changes. Although, as always, it's not didn't work out the way it should have. But the big change was that the Prevention of Corruption Act, as interpreted and applied by the police without really any legislative basis, was that causing a loss to the government. If you took a decision and there was a loss to the government, that was defined as corruption, and that's why it was the safer thing to do was to do nothing, because at least you would not. It was dangerous to take any risk. So you bought something, the price of that thing changed. You were acting in faith, and so there was no distinction being made by the police, not by the law, between bad judgment and corruption, which was the use of many definitions, but a global definition is the use of public office for private gain. And this distinction had been lost. So we took this up and we managed to persuade people in the government to change the Prevention of Corruption Act to make this distinction, following the UK Bribery Act of 2010. We were following a very much older, as you know, UK version of the Corruption Act. I'm giving this example without going into more detail because a lot of the practices that we find difficult, like people are feeling vulnerable if they act, even if they act honestly and in good faith, they feel vulnerable, is because of the flaws in the framework of rules, regulations, and laws that we have. Many are outdated. Many are not adequate to provide a basis for accountability. I, in my work, call this the fine print of democracy. For example, look at the way the electoral college, certification happened with the Senate. The rules specify how many hours the Senate and the House can take to deal with objections raised by the Senate, one senator and one House of Representatives, and how many minutes each person can speak. Now, here we believe in having good people and leaving them vast discretion and judgment. This is the old feudal idea. And even these good people resist having these the fine print of democracy that they have to obey. And I think there's a cultural issue there. So I think ultimately the elite of this country who believe that the solution to good institutions is to have good people and give them lots of discretion and power is really at the root of the failure of our institutionalization. The solution really is to have the fine print of democracy and say you may be the finest person in the world, but you must represent you must respect institutions. So Oliver Wendell Holmes, one of the greatest judges, the most respected in the US, once said, if the people of the United States want to go to hell, my job is to help, not to tell them, look, I'm a smart guy, clever guy. I know you're going to hell, and I'm going to work like hell to prevent you from going to hell. That's not my job. So this respect for the fine print of democracy laid down by common people is necessary, in my view, within, of course, a normative framework, within a basic structure normative framework, is essential for institutionalization. So yes, the problem is that if institutionalization is impeded by paralysis of not doing anything for fear of consequences. But the reason for that is the flawed regulatory framework that we have, rather than anything else.
Mr. Datar, want to comment on that?
Yes, I think what you mentioned, what I was always been this entire Prevention of Corruption Act saying that causing loss to the government is at the heart of the problem. I was the joint secretary of the Tamil Nadu Mediation Center. In my term for 6-7 years when I was there, the government could not offer to settle a single dispute in the mediation center, not one dispute. You take, for example, in the National Highways Authorities, at any given time, they have 650 arbitrations going, because whether the dispute is 10 lakhs or 20 lakhs or 20 crores, nobody will take a decision that, look, there's a claim of 10 lakhs. I think 6 lakhs is justified. Let's settle for 6 lakhs. They'll say, no, why did you give up 4 lakhs? You should have claimed the entire 4 lakhs, though it is absolutely legitimate. So that's the point. You take at the lower level also, take any sensational case at the magistrate. Have you ever heard of an important case, a person getting bail at the lower court? Or a simple matter like 1 gram of drug or some small thing. In Madras also, simple arak delivery, the trial court very rarely gets the bail. You have to go to the Sessions Court, High Court, because everybody is scared that if I give too much bail, there'll be some remarks in my CR and so on and so forth. That's the fear psychosis. As an income tax lawyer or an excise lawyer, an assessment is reopened on a ground, and I tell the person that, look, what you're saying is as absurd as saying 2 + 2 is equal to 7. And Supreme Court has said so-and-so, and 2 + 2 is 4. You can break your head against the wall. He will simply confirm the demand. And until you go to the tribunal, you will get no relief whatsoever. This is a complete malaise. And I keep joking that sometimes at the lower level, it's a tension-free practice because you know you're going to lose in any case. So you have to only get some justice above. But this is a very, very serious problem. Half the load on the High Court can be resolved if simply the lower courts and the lower officers follow the what you call the fine print of not only democracy, fine print of the law and the judgments of the Supreme Court. It's a serious problem which has to be addressed.
I want to take you back to what you mentioned about tribunals, and of course the very welcome move to place all tribunals under the Law Ministry. At least in theory, it will insulate them from political interference. I hope it plays out well and that the intention is honored in practice. But I think over time, tribunals have not, again, performed with great success, either because while you might get judicial members there who come with the right background, administrative members are not necessarily appointed on the basis of either exposure to law or merits or even a thinking ability. They get there for other reasons. And invariably, they are not able to absorb the arguments advanced before them, look at the relative merits and demerits, and then pronounce, because they haven't had the right kind of training of looking at two sides of an issue and then saying where merit lies. Also, I think what in the early days at least was mentioned, I hope it's not the case now, is that the minute you appointed a retired civil servant as a member of a tribunal, he or she felt obliged to demonstrate independence of an extraordinary quality and therefore went against the government in matters where it was crystal clear that there are a few cases where the government was on the right side, not too many, but a few. But even in those cases, because the government had to be seen as not having any influence, and because of that kind of an imaginary fear, that the reputation might get impacted, decided to rule against the government. And I've heard this from a former judge saying that, of course, he saw me as a part of the bureaucracy in those days, and he said, you guys set up the tribunal thinking you can escape from what you see as our clutches. Serve you people right what you got. So I am wondering whether the entire tribunalization experiment has met with the kind of success it was expected. Speedy justice, not too procedure bound, and things of that kind. I don't know whether that has worked out.
Well, it's a very, very large problem, but I'll just address it quickly. Basic idea of tribunals was tribunals where there are highly specialized subjects like taxation, primarily taxation. Then you had the tribunals within the judiciary, like a motor accidents tribunal or rent control tribunal, where you didn't have to go into complex evidence issues. You could decide the matters on simple points. There was just one appeal and a revision and so on and so forth. But this tribunalization, which has really galloped after 1988, is where everything has gone to a tribunal, whether it's a patent case or a company case and so on. And my basic objection was that nowhere in the world is there any company law tribunal. If it's a list between private parties, then you have to go to the judiciary. You can't take it out of the judiciary. There is a famous Canadian Supreme Court case where rent control cases were taken out of the civil courts because judges were slow. They didn't know that. I mean, the usual complaint, judiciary being slow, expensive, etc. And the Canadian Supreme Court says if it's a matter of resolving a legal dispute between two private people, then the solution is not to create tribunals, you create more judges. So that's one part. Secondly, in tribunals, here the difficulty is you have a specialized tribunal, like you have, say, intellectual property appellate board. So you expect the person to be knowing intellectual property. It's a complex subject. Or if it's company law, you expect the members to be knowing company law. But then because you ultimately have a specialized tribunal, you have generalist members. You have a high court judge who may have never dealt with company law. You have an IS officer who doesn't know company law at all. But then you require the services that he has to be rank of a secretary or additional secretary. So you get totally generalist people doing specialized service, creating an absolute disaster. Absolute disaster. And secondly, this, I personally believe, and I've been canvassing for it, don't have tribunals as a post-retirement job. You create tribunals like what is the income tax appellate tribunal, where a person at 40, 45, a lawyer decides to opt for a judicial career. He becomes a member of the tribunal. And then the tribunals are taken as part of the district judiciary, and some of them get promoted to the high court. So make tribunals as a step towards the resolving disputes, not with retired people, but with younger qualified people who can be trained, who can be specialized. For example, in income tax, throughout my life, I've been in the tribunal for most of the time. The lawyers who appeared for interviews were practicing in the income tax side, so they knew the subject. Chartered accountant knew the subject. It was such a wonderful thing appearing before the income tax tribunal. No? In fact, it was one of the greatest tribunals ever formed from 1941. And one thing, mind you, it's very remarkable that this income tax tribunal came in 1941. And at that time, the colonial government placed it before the Ministry of Law, saying it should be completely independent. And now the government filed an affidavit in our tribunal case saying that they will not allow tribunals under their ministry to be in the law ministry. Yes. So it's a larger problem. Yes. And other main issue is housing. Infrastructure is not there. You have tribunals. The whole point is you first start a tribunal, and then you start hunting for the accommodation, staying residence, etc. We were suggesting and ultimately Supreme Court has finally come down and said you must give a compulsory allowance of 1,50,000, because the housing allowance was such that nobody could even stay in a garage in Delhi with that kind of allowance which was given. So who is going to come? I know many good people have refused to be members of the tribunal because the infrastructure is bad. You don't have service conditions. You don't have any kind of infrastructure support. So if you decide to have tribunals, then make it work. You can make it work. How much would it cost? For 5, 6, 10,000 crores? Not much.
I have personal experience of that when one of the presiding officers of the Securities Appellate Tribunal, Chennai-based gentleman, Justice Kumar Rajaratnam, was posted to Mumbai. Yeah. And the government couldn't find a house for him. I had to offer him a flat from the IDBI. And I did feel bad about it, that somebody holding that kind of a position was tucked away in one flat because he needed a roof over his head. And he did mention to me that if you hadn't done this, I would have conducted the court or the proceedings on the pavement. So, so I had no responsibility to give him that, but I heard about it. I said I had some facility. We made it available. I want to go back to Dr. Mohan on one issue. Over time, have you seen the state governments and, of course, the local bodies reduced to relative non-entities? I remember many, many years ago, a few items were taken out of the sales tax and put in additional excise duty. These were major revenue earners for the state government. They lost out on that. Relatively recently, we've had GST with all the problems that are there. And then the state government's not getting their share at the appropriate time and being told, go and raise money from the market, we will support you. So given this kind of disempowerment of constitutional bodies like the state government, and also constitutional bodies like the municipalities and the panchayats, they've got constitutional status, courtesy the amendments to the constitution, but no money, no clarity, and then very deeply politically divided at the village level or the block level or wherever. Is there a need to revisit? I know it's not the easiest thing to do. Is there a need to revisit some of these arrangements to see that at different levels there is adequate empowerment, of course, coextensive with responsibility and capacity? You're on mute, Dr. Mohan, you're on mute.
I put it on mute so as not to disturb the discussion. Or just turn it back on. No, it's a very, very important issue. It requires very extensive consideration and debate. But I think, again, at the core is a conceptual problem and a conceptual compromise that was made when the 73rd, 74th amendments were adopted, which is that, as you know, the tier of local self-government is not really an independent constitutional tier. We simply have union and state. And the local self-government, from a constitutional law point of view, is part of the state and like any other state institution to which power is devolved according to a model suggested in the Constitution, not mandated by the Constitution. Therefore, in the absence of some genuine autonomy from the government, I've had some experience of that briefly in Kerala when I was a member of the planning board here, and I wrote a detailed report on decentralization in Kerala, which is probably one of the better states in terms of the experience with decentralization. But even here in Kerala, there is the independence that successful local institutions of local self-government have in other countries is simply not there. And without that clarity of role and responsibility, you also cannot have accountability mechanisms. So yes, you mentioned accountability when you spoke earlier. That's a very important point. So I think, yes, we need to have more of the fine print, constitutional fine print of devolution, decentralization, and deconcentration of power, because without that, we can't have strong institutions in such a vast and diverse subcontinent as we have in our country. So I think there's a huge agenda there. There was a time when there was a lot of attention to that, but I think the political class and perhaps your own, your own tribe, the Indian Administrative Service, have a lot to lose. The political leaders, if power is genuinely devolved, they have a lot at stake, and they have resisted that kind of genuine the deconcentration of power, the devolution of power, and decentralization of power. But I think as we look at the roadmap for the next 10 years for institutional strengthening, clearly addressing these fundamental failures in the model of decentralization to strengthen them, I think is going to be central and going to be very crucial. So one challenge is, how do we bring decentralization back on the table when we now have a union government who is always thinking of everything as one, right? One this, one that, standardize and homogenize the entire country, which pulls in the opposite direction. So I think we need to bring this issue back on the table and and go back towards the original constitutional vision of federalism. And I think it's not right to say that we're quasi-federal. We are federal, and I'm not going to go into that. And of decentralization and Swaraj, local self-government, as a very important political objective of the Constitution, which must be realized.
Oh, I fully agree with him. In fact, this constitutional amendment has just been there in paper. You have created a schedule setting out the subjects for these things. And I also feel that why can't we take baby steps instead of implementing it, everything in total? You can start, okay, give these out of these subjects, start with 5 subjects, see how it works out. And it's just been in theory, unfortunately. Like I said, we know what to do, but we don't know what we know. That's the problem.
I'll make a light-hearted comment before turning this over to Tirthankar for the questions from the audience. Once we were looking at the 3 lists, 4 of us, one of whom very proudly said that he had never seen the Constitution. And when he was told that there was a union list, a state list, and a concurrent list, he said, now things are falling in place. The concurrent list is a signal that the states ought to concur, isn't that? Tirthankar, take it away.
Let me start with the questions, please, Mr. Damodar. And please feel free to direct the questions to any of the members of the panel, please. And if you would like to field some, perhaps that will be one for you as well. So I think one question was on accountability. So we take steps, we announce plans, but in India, implementations always remain tardy. Why does that happen?
Good question. Who is it addressed to?
Anyone in the panel. Anyone.
Okay. Then let me make a brief comment and then I will turn it over to the panelists. The Central Vigilance Commission has had several distinguished chiefs over time. I had occasion to call on one of them and I explained to him that the problem in this country was that accountability was defined, as I mentioned earlier, in terms of errors of commission and not in terms of errors of omission. And I gave him 3 or 4 examples where nothing had been done because nobody had acted on what he or she was supposed to do. He said, I will fix that when I revise the vigilance manual. I lost interest in it afterwards. I don't know whether the vigilance manual was revised. Just one more comment. Implementation, execution, call it what you will. I had a conversation with Ram Charan, the management guru, some years ago. And I asked him, as many of you know, Ram Charan started writing books at a very late stage in life. But when he got started, he started turning them out like there's no tomorrow. And several books came out. I asked him, which of your books has sold the most? So he said, that's the easiest question I have ever been asked. My book on execution sold twice as much as all the other books put together. That is where the rub is, execution, implementation. Nothing else is important, but I request the panelists to comment. Anyone to take it.
Yeah, I think I'll follow what Dr. Gopal says. After he finishes, I'll say something.
Okay, great.
Thank you. No, I think this, again, I go back to, I've for countries and what I find is really the absence of standards, measurable standards. So we are looking at accountability without actually clarity about what we are holding people accountable for, how, when, and why. There's very little clarity. That's what also creates paralysis in the minds of, like for judges, play safe judging. Be careful at the lower courts. Be very careful because there's a lot of arbitrariness and you can be charged with wrongdoing without, because someone else has a difference of opinion rather than because you're violating the rules. So I think we have to approach accountability by starting at what I call the swine print. I say democracy, I mean as a culture. Democracy, kratos means power, demos means common people. So democracy means a system where kratos, power is held by demos, common people. So institutionalization should be used to ensure that power is in the hands of common people. And for that we need a detailed fine print. So take the judiciary, for example. Now, when I say performance standards, I also refer to role. What is the role of the judiciary? I'm totally with Mr. Datar on his concerns about tribunalization. We've had conversations before this, and I think we followed out the civil side of jurisprudence in our country by handing all this over to tribunals without realizing that the role of the court is to determine the existence of rights. You go to Evidence Act, it says the existence, non-existence, nature or extent of right, liability or disability. That's the definition of fact and issue. That's the rule. Only a court can do that. Application of rights, like in tax tribunals, how do you apply those rights? Those can be tribunalized, but we need to have clarity on roles. Then we need to have clarity on how those roles will be performed, how they will be measured, and completely independent methods for measuring accountability. The basic problem in our country is there's too much of discretion, personal discretion, in the hands of the bureaucrats, in the hands of the judges, in the hands of the politicians, and in the hands of the private sector, frankly, compared to the private sector anywhere else in the world. Too much of discretion, which is preventing accountability. So again, another very big topic, which requires very detailed analysis.
Yeah.
Mr. Datar.
I was just about to mention Mr. Ram Sharan, because though I'm a lawyer, I keep thinking of how management practices can be applied to improve the disposal of cases. I've been trying to work with the Kaizen can be applied to courts and so on. But the point is, I don't think we can blame the government. All of us are blamed. I mean, it's said that out of New Year resolutions, 96% are lost by the first 10 days. So like the same thing, government, you announce big schemes, and I think it was best expressed by Bill McDermott, who was the main person in charge of SAP. He's written a wonderful book called The Winner's Dream. And there he says that audacious goals must be complemented or backed up with micromanagement of reality. Yeah. Micromanagement of reality. You set a goal of 125 million jobs. How do you do it? In fact, if you see in one of Pranab Mukherjee's budget, para 111, I'm reviewing the para, he simply said we're going to have a national legal policy and all areas will be wiped out in 5 years. How? I mean, it's very easy. And again, there are goals which are difficult to implement, and they're very simple. Like, it's very easy to distribute 1 lakh free color televisions or give 20,000 gold chains. So all these things are easy, or build 10 lakh toilets. That's easy. But the more difficult is achieving a 5 trillion mark or creating jobs. These are more difficult, which has to be applied. And before you make such announcements, how do you follow it up? You have a RERA, real estate, you simply announce a RERA, have tribunals. There are no tribunals, there are no places to work on, so on. So I think audacious goals are good, but it must be before you set the goal, you think of how you're going to implement that and then announce it. Yeah. No point saying I'm going to lose 12 kilos in 3 months and then you don't follow the diet, then what's the use?
Tankar?
Yes. My next question is, the objective of a republic is to have its elected representatives provide the framework that allows citizens to live their lives to the fullest. The performance in doing so is measured at the hustings. But what happens when the measure per se becomes the objective? How does one look at alignment of objectives?
I think Dr. Mohan can come in on that.
Yeah, could you just repeat? There was a problem in hearing the last question.
Sure, Professor.
Patnaik, would you mind repeating the question?
Let me repeat the question, sir.
Yes.
The objective of a republic is to have its elected representatives provide the framework that allows citizens to live their lives to the fullest.
Yes.
The performance in doing so is measured at the hustings. But what happens when measure per se becomes the objective? How does one look at alignment of objectives?
Yes. No, I think the implicit question is that when election has become the main objective of political parties, there is a black market in state power, and a lot of parties and political leaders are traders in that black market of state power. I agree with that. I would simply say that the objective of the republic is actually to create it's in Article 38. The objective of the goal of the republic is is not to simply have legislators give us a framework. It is in Article 38. It is to create a social order in which justice, not economic order, not political order, a social order in which justice, social, economic, and political, shall inform all institutions of national life. It's to create a new society. And that's been forgotten completely. And by the way, I just want to say to Mr. Datar that when I said eighth decade of independence, the first decade of the U.S. Constitution was 1787 to 17, the U.S. Constitution. And our first decade was 1950 to 1960. So as I measure it, the eighth decade of the US Constitution was 1857 to 1867. And the Civil War was 1861 to 1865. And our eighth decade is 2020, 2030. It begins 2020, January 20, the beginning of the eighth decade. So that's why I said we are curiously in the eighth decade during which the Civil War occurred in the United States. And I believe we are actually North India, not South India. North India is in the middle of a civil war over slavery of a large number of its people. And fortunately for us, because of the Constitution, it's being handled more peaceful way than was possible in the United States at that time. I just wanted to clarify. That's my calculation, so that Mr. Datar can correct me.
Actually, there's a big debate. I've been having this discussion with my brother. When does the decade start? Does it start in 2021 or does it start in 20? Is the decade 2021 to 2030? Or is it 2020 to 2029? That's the big question. So I don't know. I mean, I've got mixed answers to that. So,
would you start the first decade in 1951 or in 1950?
Okay, fine. If you take it 50 years, then you can take that way. Yeah, that's a good point. But either which way, I think on this question of election, one major difficulty or one, I can't say a drawback of election is that it all depends. You see, ultimately, it's not the constitution which is violent. It's the people who run it who ultimately would turn out to be not as what the constitution makers. Now, for example, you take this sensitive issue of reservations. Like now we're going to have the Tamil Nadu elections. Now the main thing is there's a particular political leader or political leaders who represent a particular community who becomes a vote bank. Now you say that you must give my people this particular vote. Now, as early as Indira Sani in 1980, 1990, 91, Supreme Court said you can't cross the 50% limit. But then you just make a promise to the people. They don't. They know it's not. I mean, they don't know it's not possible. But the point is, as you start bartering or compromising your own future. You start ruining the country's future at the hustings, and then you start paying a price for it. Whether it's just writing off farm loans arbitrarily, just distributing endless. The first thing anybody comes now, we're in the midst of election fever in Tamil Nadu. Each political party says, "I'll come back." One said, "I'll write off all the farm loans." One said, "I'll write off all the jewel loans." One said, "I'll write off all the education loans." Now, how does a democracy survive like this? Who's going to pay the price?
My next question is, are policy circles...
Incidentally, just to interrupt, I unsuccessfully fought the battle against freebies. I said offering a free television or offering a free computer amounts to a bribe. It's an unfair election practice, but the Supreme Court turned it down. I said that you can give what is for below poverty line, the basic needs of life, like 10 kilos of rice or basic clothing, but to give laptops and what you call your television sets and gold thalis, etc., would be completely unconstitutional. But unfortunately, in the Subramaniam Balaji case, we lost that matter.
But it also sends the wrong expectations, doesn't it? I mean,
Tankar, before you come in, I wanted to share something on what Mr. Datar mentioned. When I was in the Ministry of Finance, in one of those so-called enlightened moments, I went to my boss and said, "You should write to the Election Commission saying that the promise of loan waiver is a corrupt electoral practice." He had this disbelieving look. After all these years in government, is that what you came up with? He was a good man. He said, "Go ahead and write." So I sent off that letter, and after a week, I checked with a friend in the Election Commission what happened. He said, not related to this, but otherwise we had an all-party meeting with something else. And the then CEC mentioned this matter, and this was the only matter on which all parties were agreed, that you should not have any such provision.
In fact, just to complete this part, when I argued this case before Justice Gogoi and Justice Sadasivam, one suggestion was made by the bench: why can't the Election Commission make a rule under the model guidelines that you will not offer these freebies without the financial resources? And the response by the Election Commission was, we will do it provided all the parties agree.
You do have alignment of objectives on that front, I'm sure. Well, my next question is, our policy circles usually react to situations rather than work with a long-term plan. This sort of shows up in all our planning and all our future development. Does this lead to our undoing time after time?
I think Mr. Damodar is the best person to answer. He's been in the forefront of making policy for so many decades.
Tirthankar is an economist and he will appreciate this most certainly. You have planning and you have planning for implementation. You have implementation, but you don't plan for implementation. Merely writing out a plan, that's a statement of intent. And then you believe it will get implemented. You know, many years ago, I mean, it's not the best illustration, but I think it serves my purpose for today. Many years ago, the Illustrated Weekly had a lot of ads for selling things, and they had, of course, a note at the end saying that you buy at your own risk. We don't know about this. So somebody said they're the perfect cure for mosquitoes. And it was relatively cheap. And somebody wrote into them and got by post 2 wooden blocks. So he wrote back saying, how will this cure? He said, that's simple, because this is the intermediate stage of planning, which is getting those 2 boxes and implementation. He said, you got to catch those mosquitoes, keep it on one block and hit it with the other. Then you can kill the mosquito. So you need to actually say, you can announce anything. For example, I'll give you another example. Some scheme which involved sending people out to the remote areas, especially in the Northeast. And there were provisions for 3 posts. And a member of the Planning Commission turned it down, saying, how will they pay bridge? Give them a 4th person. So you get that kind of enlightened interventions also sometimes, which put paid to all plans. But if you plan and don't decide how you will implement, implementation won't get started.
I guess one important ingredient in that aspect is what Dr. Gopal mentioned of measurability of performance. It is important to see how policy outcomes are measured after maybe a couple of years, 2 years, 3 years. If that does not happen, then policies remain policies on paper. Implementation always remains delayed for all our large projects. I have 2 more questions, gentlemen. Could you shed some light on the
Could I come in briefly on this public on this policy question?
Yes. Yes.
I just want to say that we country of planning during implementation, and it's kind of a soft recognition. We plan as we implement. In contrast with a lot of other countries, planning is much more efficient, where they put a lot of planning. They front load the planning. So I did some research and I found out that it takes 25 to 30 years for a major piece of legislation to be put into effect in the US and Europe. So take, for example, the introduction of the euro, the currency. It took about 25, 30 years from when it was first proposed for the coins to hit the cash register or the table, right? So there's a huge uploading of very careful planning. Or take Environmental Protection Agency standards on emissions. Usually there's a 20-25 year lag, by which time technology has changed, industry practice has changed. So by the time the new technology the new standards are introduced, the people and society have also moved. Whereas we first introduced a law, look at the amendments made to the Indian Penal Code after the very tragic Nirbhaya incident, right? The speed with which it moved. And has it really slowed down has it had an impact on the problem? And, there is not much evidence that it has reduced the safety of women in the country which is really the most important objective. So we are not, I think, as in government, does not believe in, for various reasons, bureaucracy and the political class, in putting in front loading a lot of detailed thinking and planning into planning. So this is a very important issue, another very important reason why institutions are not working well in our country. So that's why I wanted to intervene. I agree.
Thank you. Thank you. If I may go to my second last question, gentlemen, could you shed some light on the route to be taken towards improving institutional capacity? Many times, the road to hell is paved with good intent. So I know initially you did mention about creating institutional capacity in the judiciary, but this is probably a general question. How does one go about improving institutional capacity?
I come in briefly.
Yeah.
Institutional capacity, there are two elements to it. One is the arithmetic, having adequate persons. Two is the relevant skill sets. You can get in all manner of persons. If you don't have the right skill sets, you will not be able to do anything. I know there was a point of time in SEBI where there were 4 chartered accountants in a strength of 600 officers. And all that regulatory organizations are expected to have is people who are proficient in law and accounts. We had a handful of lawyers and 4 chartered accountants, increasingly complex instruments in the market, increasingly intelligent players in the market. And this is the ammunition that was available to keep track, punish, and help to send out the right message. You need to have the right numbers, you need to have the right skill sets, and you need to continuously upgrade the skill sets. Because while it is recognized that the thief will always run ahead of the policeman, the gap should not be so much that you lose sight of the thief when you're running behind. So you must be at least as equipped in terms of skills. And then there are positions where you must hire for attitude and train for skill. If you don't have people with the right attitude, the right commitment, the right conviction, no matter what skill sets they bring. And to top it all, there must be acceptance from that universe that the institution seeks to serve, that you have put in place an institution with the right capacity, because that is when there will be legitimate expectations which can be legitimately met.
Mr. Datar, would you like to?
Yes. Well, I'll speak on what I know about the judiciary and about the tribunals. Simple thing is that, like, you know the number of vacancies, you know what are the skills required. I think basically having a system of your systems in place, like from the time a person gets appointed, you know when he's going to retire. So you know, for example, in 2021, there are going to be 9 vacancies in the High Court. Now, I don't know why we can't plan from 2019-20 and then find out who are the potential judges and then select them. Now you have cases where the Delhi High Court, out of a sanction strength of 64, they're down to 28 judges. Madras High Court, out of 60, we had at one time only 17. Now, thanks to Chief Justice Kaul and Justice A.P. Shah and Justice Kajju, we've got 64 out of 80. So look at the disparity. Madras has 64 judges out of 80 and very good judges, whereas Delhi has 60 and only 28. So this kind of, and Karnataka High Court, at one time only 14 judges were there for the entire state of Karnataka. So in case of this, if you have a system where people are going to be appointed, you know well in advance. Same thing for the district judiciary. You know the number of vacancies, you plan. And then, like Mr. Mohan Gopal said, not only constitutional fine print, even daily simple procedural fine print. That the vacancies for next year, by September, October, or August, the names go to the collegium. And by the time the vacancies come, they know within a week or 2, they are filled up. And also there's something called impact assessment. Suppose you're going to expand the High Court strength to 75. If there are 10 more judges, do you have the housing? Do you have the infrastructure? How do you plan for that? And then you have extra number of Supreme Court judges, but there's no house. Somebody stays in the guest house. Somebody stays in Tamil Nadu Bhavan. This is not very.
I'll just supplement Mr. Datta said, with the following specific example. Until we created the National Court Management Systems Group Committee and worked on it, and it was a very complex piece of work, we did not have, and we have it now in theory, but we need to apply it, and I think it's being applied. But effectively, we do not have a method to answer the question, how many judges do we need? We went for years, decades, with a completely irrelevant proposition, relevant at some level, but not at a management level, of population judge ratio. As a result of which, a state like Kerala that has low population, but very high filing of cases per capita, had fewer judges than a state like Uttar Pradesh or Madhya Pradesh or Jharkhand, which had huge number of people, very few cases. The number of new cases, 100,000 people in the United States is about 300. In Bihar, it's about three cases per 100,000 population. In Kerala, it's about it's about 45 or so. In Singapore, it's about 100. In Delhi, it's about 45, 50. So, depending on economic, per capita economic incomes, literacy, and social development, there's a lot of evidence world over that when people become more educated, more aware, and more empowered, more cases are filed. That's a very healthy sign of a functioning democracy. But we, instead of looking at the ratio between number of cases and judges, we were looking at the cases, the relationship between population and judges, which is not relevant. So now we have switched. We have switched to start to look at judge case ratio, but that is a second set of complex problems. You can't. How do you bring weightage to cases? How can you compare a CBI case to a fender bender case of a magistrate? So we have to introduce a method of finding out how you weight a case. So we did a lot of work to link a unit system that judges have, which looks at their performance and rewards their performance, and use that method to weight cases. So we have a lot of fine print to develop without answering the question, how do you know how many judges a court needs? You can't answer the question, how many judges does India need? And you can't do this hiring in advance. Maybe you're hiring people you don't need at all, or you're hiring too few people. So we have a lot of fundamental work to do. And I also wanted to say, since we're running out of time, to Mr. Tatar, that in a very slow and in a very and I want to say this to the credit of the judiciary across the last 15, 16 years, we have quietly institutionalized, since that's our theme, institutionalized 3 or 4 things in the judiciary. First is created a network of judicial academies across the country with good quality standards, integrated that into the working of the judiciary. So judges are coming together and discussing issues to implement solutions that they identify. We created the National Court Management Systems Committee, which are state and many states district court management systems committees, where judges sit together with government officials, statisticians, and a very nitty-gritty nuts and bolts people to find out how to create an extra bench for witnesses to sit, how to to solve very practical, simple problems. So we created these 2 institutional frameworks. We've created a very good framework of statistics, which we didn't have. So we've created, through the work in the Judicial Academy, we've created NatGrid, which is now publicly available. We've created a national system of data and statistics. Because I requested Justice Maruka to do a PhD with me at National Law School for the little computerization he was doing in Karnataka and the Bangalore High Court. That then developed into the E-Committee. He did that, he published it as a book. He was appointed chairman of the E-Committee, and there's been massive increase of computerization and technological injection into the judiciary, which we cannot ignore. And lastly, we've created a simple formula out of the Judicial Academy, which is now penetrated throughout the judiciary, called 5+0. 5+0. And 5+0 means every court should aspire that no case in its court should be more than 5 years old. 5+0. There are several high courts which have actually statistically achieved 5+0. Once you achieve 5+0, move to 4+0. So we started to make aware of how to monitor these cases, and they've been actually quite receptive. We've also created performance standards for the first time on several issues: very infrastructure, quality, timeliness, and we have written detailed reports, including one on court management and case management by Justice Khanvilkar. Very detailed document. It's been developed, and in a non-mandatory way, we've uploaded it onto the Supreme Court website, and it's available on the website if you look under publications, NCMS. And so today, there are many high courts in the country where to build a courtroom. There is actually on the Supreme Court website a set of standards, because the idea was that we should have a minimum set of standards on courtrooms. So we have started to create these performance standards. So in a very quiet way, we've started to build a institutional foundation of the judiciary that was missing. And without that, frankly, you can't really, as Mr. Datta said, you can make short-term solutions, but it's not going to take you anywhere in the long term. So I think we've started with the support of a lot of the Chief Justices of India. And you know, the Academic Council, on which you and I are, provides a platform for our input into judicial education. We've created a platform for institutional strengthening. Institution meaning rules and how they're enforced, not organization strengthening, which is slightly different for the judiciary. So I think as we end, we should end on a positive note of what we've been able to achieve as well. And I think that these efforts are creating capacity. This is institutional capacity. The capacity to have data, capacity to measure performance, capacity to assess needs and find solutions and implement them. So certainly in the judiciary, I think we have created a lot of capacity which did not exist 15, 16 years ago.
I think these are certainly salient examples of institutional capacity building. Truly, I mean, one would actually hope that similar capacity building exercises are taken across, other segments of the society, other segments of the, executive. One keeps hearing about police reforms, for instance, but I believe there is a gap between what Professor Gopal, you described about judiciary and how one actually sees our police and paramilitary forces. Which brings me to the last question, this panel, gentlemen. It is a little bit of I would leave it to you, gentlemen, to allude the question to current instances. But the question is, we have concerns of judicial overreach, but is the judiciary only filling the gap left by the executive and the legislature?
Well, this is going to be a perennial controversial issue. Well, it is well settled. For example, the classic example is Vishaka, where there is a vacuum. Like on sexual harassment, there was no law, and Justice Verma's famous judgment that we will implement certain guidelines to prevent sexual harassment at the workplace till Parliament steps in. So I think there are many, many cases where what you accuse judicial overreach may not be justified. For example, in Tamil Nadu, maybe at the Green Bench, but for the judiciary, the environmental degradation would have been far, far worse. Even in the case of forests, Supreme Court stepped in. Virtually, it was the National Forest Ministry for everybody else, but it was necessary because there was so much of deforestation and nothing was being done. Take the mining cases and so on, where the judiciary did step in. There was an overreach, but it may have been necessary because of the political compulsion in India. But where it becomes problematic is when the Supreme Court makes or passes orders which are completely beyond its remit. Like, for example, overnight you simply say diesel vehicles about 2-liter 2000 cc will be banned in Delhi. Now it has huge adverse consequences, and I mentioned at the Judicial Academy in Bhopal that when I've got under the Motor Vehicles Act, my vehicle is perfectly legal. How does it become illegal because Supreme Court order? This liquor banning of beyond 500 meters, all liquor shops to be closed. So I said India was perhaps the only country where what is statutorily legal becomes judicially illegal. That I think should not be permitted. If it's Parliament, it has to be allowed. I mean, you can't step in and you see, like Karl Popper said, the biggest thing is that you think that what is good for somebody and you push down your throats. There should be a clear demarcation. So I think in certain steps there has been overreach, but it's not everything bad. It's a kind of it's not black and white. There's shades of gray where Supreme Court rightly stepped in, and there are cases where it did not. It should not have gone into the particular situation. But this is a problem that's going to continue. And I think at the high court levels also, there is perhaps an intention to start reforming, how much homework the school children should do, what should be done for mosquito prevention. I mean, that's not the remit of the high court. So sometimes it just goes beyond the limit. I think Mohan Gopal.
Yes, I would say that if it took a slightly different view, and you say, what is, you asked earlier, what's the purpose of the Constitution? And I said that in Article 38, it is to create a social order in which justice, social, economic, and political shall inform all institutions of national life. And recently, the Supreme Court, Ravindra Bhatt's judgment in February 2020, very wonderful judgment. In this context, he defined the Constitution as a compact between people, as an agreement between people on the relationship of people towards each other, on how we will behave towards each other. And I argue in my academic work that justice is a standard of human conduct on how we treat each other, freedom, equality, the core values that must inform how we treat each other set out in the preamble, for example, equality and freedom. And we say justice is secured when behavior informed by these values crystallize and actually are reflected in real life. This is the commitment of the state to the people, or mandate given by the people to the state. Now, what cannot happen is that somebody drops the ball on this, or this falls between the cracks. The world is simply not a question of simply drawing lines between executive, judiciary, and blah, blah, blah. All of them together is the state. And the state has been given mandate by the people of India that you must secure a society in which a certain standard of relationship based on constitutional values prevails in human conduct towards each other. And institutions are operated by people if an institution is only a set of laws. And the state must ensure that this is fulfilled. And so if any member of the state, executive, legislature, or judiciary finds that the ball is being dropped, they must step in. They must step in. They cannot allow the ball to be dropped. And I think that's a difference between our approach to justice as a standard of human conduct than say Montesquieu's approach, which I'm not saying there are any fundamental differences, but we must understand. That's why I said there's a tension between the ideas of institutions and rule of law and the ultimate objective of the enterprise, which is to create a kind society, a society where people care for each other, respect each other, and look after each other. That is why we fought the freedom movement. And so the ball cannot be dropped on that. And the judiciary sometimes steps in to catch the ball when the executive drops it, and the people celebrate that. Sometimes the judiciary drops the ball and executive in its own deft and clever way, which Mr. Damodaran knows more than us how they do it, they catch the ball when the judiciary drops. But ultimately then the people celebrate bureaucrats like Mr. Damodaran who catch the ball when others drop it. Because people understand that the state has to fulfill the mandate that we people have given to that state. So I think we should take a very big picture view on this question and not try to look at it as a narrow, big scattered challenge.
Thank you, Dr. Gopal. Thank you, Mr. Damodaran. Thank you, Mr. Datar. After the discussion today, one feels like I think Mr. Damodaran's comment at the outset when he said that the observations from Professor Gopal would some of us would think a lot more in detail about these observations going forward. So the entire discussion happily has been on those lines. Clearly, a lot for us to think over. We touched over several topics here. We touched over the importance of institutions. We saw how our country is in the current state, and how we saw comparisons between us and the United States. And I like your argument about the 8th decade. course. I would now request each one of you to give some final comments. I know there have been several topics that have been discussed. We did touch upon a fair amount of them, but anything for us to take home. I'll start with you, Professor Gopal.
Yeah, thank you very much, Mr. Patnaik, and thank you for those very wonderful comments and your interventions. Now, I think the takeaway I want to say is that we recognize, that institution is not, it's always work in progress. Institutional strengthening and keeping institutions strong, namely coming up with the right rules and making sure they work to achieve the larger goals that we have of creating a just society. It's constant work in progress. I refer to the Constitution as a site of revolutionary struggle. It's a site of struggle. People come together rather than fighting on the streets like they did in the US in Washington, D.C. They come to institutions created by rules and struggle to achieve a better society. So I think we should, first point I want to make is we should not think that institutional strengthening and reform is something that can be finished in 1 decade and we'll have fine institutions. It's a constant struggle. It's a never-ending struggle, and it's part of the process of the fabric of human interaction with each other. Second is that this struggle involves very political issues. For example, Mr. Datar referred to Supreme Court saying that 50%, there cannot be more than 50% reservations. Actually, there are many judges who have said it's unconstitutional, like Justice Chinnappa Reddy, one of the most distinguished judges of the Supreme Court, in his book on the constitutions, Constitution and the Court, Summits and Shallows. He says that the 50% limit is unconstitutional in his view. And there are many people, including myself, who believe that this is an unconstitutional limit on reservation. So should it be resisted? Yes, it should be resisted within the framework of the law, through the courts, not on the streets. So we must understand that some aspects of what we consider good institutions and bad institutions are political, and political issues must be decided in a democratic manner by people, because democracy means Plato's power is in the hands of demos, common people. That's the second point. But the third and last point is, separate from that, like I talked about, see, for example, we developed the concept of docket exclusion, that India has not too many cases that are being filed, and we change the narrative on that. That's something we can all agree on, that people must protect their rights. So let's find the challenges constantly, not just now for the next 10 decades, but forever. After 240 years, the US is still battling institutional strength and institutional effectiveness. So we must always try to find common ground where we can make progress, solve problems, and fight against stupidity and idiotic rules and idiotic habits which affect all of us, and make progress. And I think we need to do that. And it's all the more important for this country because, frankly, in the 8th decade of independence, we're trying to transition from a feudal society where oligarchs feel they can good oligarchs can take the country to where it should go, towards a new society where power must be in the hands of people, and therefore needs a lot of fine print. So our challenge in the next 10 years, I think, is to write and build up the fine print of the institutional framework of this country. Thank you.
All 3 points well taken, Professor. Mr. Datar?
Yes, I do agree with Professor Gopal on a lot of points, except the reservation issue, which I have my own strong views. And that's the beauty of our democracy. We can have completely different views and yet be friends and yet discuss, debate. As he said, you can idiotic ideas, but in a democracy, idiotic ideas also have a place. So they are entitled to be voiced out, and that's the beauty. My one grievance is that I think there's just too much of negativity around us, As a lawyer, we have so much to celebrate. We just take our courts for granted. We have very, very competent civil servants. We have very able parliamentarians. I've had the opportunity of appearing for parliamentary committees, and I was astonished at the amount of research they had done when I gave evidence in 3 parliamentary committees. So I think it's not that's all gloom and doom, and that's one most depressing thing of reading newspapers or watching television. It's a daily doomsday scenario. Everything is gloomy, dark. I don't agree with that. There's so much to celebrate. We have basic institutions, and like Dr. Gopal said, it's work in progress. We will keep on improving it. We got a wonderful system, and what happens is, you take out one or two bad judgments, but you forget the 90 judgments which are very good, where they dispense justice. Like we say, there's everybody talks of a case coming after 40 years, but nobody knows that there are so many courts, as he said, where the cases are disposed of in 3 to 4 years. So I think that there is a need also, maybe for excellence enablers or for other bodies, to celebrate the good parts and tell people that, look, there is a lot of hope. Just look at what has happened around us. What happened to Pakistan? What happened to Bangladesh? What happened to other countries? Their constitutions have gone again and again, and we have still resolutely survived in a robust constitution. So I think I'm an eternal optimist. I think there's a lot more. And I think in 2030, we are going to be far better off than we are in 2021. That's my firm belief. And institutions will become stronger, and if we put our heads to it. And I think it's also not just our thing of just blaming the government. I think each one of us should resolve that in our own little way, as a lawyer, as a doctor, etc. We do our best to better the system in which we work.
No, I couldn't agree more, Mr. Datar. I remember Ramchandra Guha's book, India After Gandhi. Thank you, sir. Thank you, sir. One of the comments he makes was that right after independence, the big question was, how can a country like India with so much diversity actually survive? The odds were much higher for a country like Pakistan, which was far more unified, and people were of a similar age. And 80 years later, here we are. We stand, and India stands resolute. We are one of the world's largest economies. We do contribute significant amounts in all spheres of human achievement, and that positivity takes us to the next decade. Definitely, sir. Definitely. Mr. Damodaran, certainly last but not the least, your words, please.
I have 4 points, Tirthankar.
Please, sir.
The first is, in all situations, this is a personal belief, in all situations, we must do what the doctors do. Diagnosis, prescription, treatment. First diagnose what's wrong, then prescribe what should be done, and then carry out the treatment. Without the treatment, it fails. My second point is, activism is good, whether it's a judicial activism or anything, but you must draw the line at adventurism. Activism should not become adventurism. Give examples of that. My third is, and this was music to my ears to hear it from Mr. Datar, we must be positive. I have for long believed that this country will benefit if we have an all-party resolution to suspend cynicism for 3 years. That cynicism should be made illegal for 3 years. I think we will do very well. We are the biggest critics of ourselves, and often that criticism is excessive and unjustified. And my fourth comment, it's a wish, it's a hope, it's a prayer. Replace conflict with conversation. I think we have avoidable conflict because there's no conversation. Thank you.
Especially in this day and age, we need conversation, we need dialogue. We need dialogue. Ladies and gentlemen, that brings us to the end of yet another really thought-provoking webinar between NSE and Excellence Enablers. I thank all 3 panelists. I thank Professor Gopal. I thank Mr. Datar, and I thank Mr. Damodaran. I thank our MD and CEO, Mr. Vikram Limai. From NSE's perspective, I also thank our marketing team for their efforts for this. And we go this evening with thoughts and something to really ruminate about. Thank you, everybody.
Thank you.
Have a nice evening.
Thank you. On behalf of Excellence Enablers, let me thank all of you for your participation in this webinar.
Thank you.